Marriage is not just a personal commitment, it's also a legal contract with rights, responsibilities, and sometimes complex consequences. In today's episode of Legally Speaking with Rest the Case, we're diving deep into Indian laws with a focus on Hindu Marriage Act, where we will touch upon maintenance and alimony rights and how the newly implemented criminal laws impact and shape matrimonial disputes. Whether you're married, planning to get married, or just want to understand your rights under the Indian law, the conversation is you. Joining us today is Advocate Ranesh Anand, a legal expert who has worked extensively on matrimonial and family law matters. So, we will begin. First of all, welcome to today's podcast, Advocate Anand. Uh, we will
Thank you.
start.
Thank you for having me.
Yes, it is a pleasure, sir. We will start the conversation by, this question, which is what legally constitutes a valid Hindu marriage under the Hindu Marriage Act?
Yes, so it's under Section 5 of Hindu Marriage Act 1956, which lays down the guidelines that what will be a valid Hindu marriage. The first thing that needs to be noted is that there should be two persons, one male and another female. So that's the first requirement. Why I am focusing on this? Because nowadays we are in a debate. Debate is going on regarding the gay marriages also. So, to understand that, you have to understand the complexity or the fact that is involved in the Hindu Marriage Act. Hindu Marriage Act clearly states that a marriage can be solemnized between a man and a woman. Number one. Number two, they should be of a legal age. It's 21 for boys and 18 for girls. That's the minimum marriage age. And then both the partners of sound mind. Nobody should be of unsound mind or anything like that. It should not be a second marriage. So these are the guidelines which are there under Hindu Marriage Act. And once the marriage is solemnized, you have Section 8 of Hindu Marriage Act, which gives procedure for registering of that marriage. So you have to register that marriage in the office of the registrar under Section 8, which this registration came after 2008. There was Ashwini Kumar judgment of the Honorable Supreme Court. In that case, it was held by the Honorable Apex Court that all the Hindu marriages needs to be registered.
Okay.
So it was made mandatory.
Yeah, so I mean, you answered my next question, which was going to be that is registration of Hindu marriage mandatory, which it is then.
Yes, it is mandatory.
Okay. And in case someone fails to register their marriage.
One more thing, if somehow you don't register your marriage, then it doesn't invalidate your marriage or it doesn't make it a void marriage.
Okay.
But for the legal purposes in life, like you're going for applying for passports or you're applying for other things where both the couples are involved, then you will require that marriage certificate. So it can create that problem. That's why it says that it is compulsory. But if you have not registered it in the marriage, but all the customs, local customs have been followed and the marriage has been solemnized in a socially and acceptable way, it cannot invalidate that marriage.
Okay.
Non-registration.
Okay.
Yeah.
And then what are the legal grounds under which a Hindu marriage can be void or voidable?
See, the first thing that if the one partner marries other person, like if the bridegroom, the male marries second time while being married to the first wife, then it becomes a void marriage, void ab initio. So from the beginning, it is a void marriage. And then if something has been kept as a secret, maybe the person is of unsound mind, then if something like that is there, then it can become a voidable marriage. where the partner can go and claim that, see, I was not told, the person is of unsound mind or is of not in a proper state, mental state is not good, or the bridegroom is of bride or bridegroom is of not of the age that is required, then it can be held as a voidable marriage.
Okay. And how do intercaste or interreligious marriages fit into the Hindu Marriage Act?
See, there is no distinction between intercaste or uh, uh, intercaste marriage. The first I'll talk about the intercaste marriage.
Yeah.
There is no distinction of caste or intercaste marriages under the Hindu Marriage Act. Only distinction that has been made that it should not be a sapinda relation.
Okay.
The sagotri relation. So in a Hindu family, you have under Mitakshara law, because the Hindu Marriage Act and all is governed by the Mitakshara law, the ancient Mitakshara law, and under that you have Gotra system. Apart from caste system, there is also called as a Gotra system. So everybody has some sort of a Gotra. What is Gotra is in another debate. Some scholars say that when this civilization and social structure and society was built, then people followed one one guru or one person. So whoever were the part of that community, that became part of one gotra, and it is said that they have same blood lineage, same heritage. So these are the issues. There are different views on that. So it is said under the Hindu Marriage Act that Sagotri Viva, or somewhere it's a Sapinda Viva, Sapinda Viva, same pind. So if you fall into the same line of lineage, then you don't get married to each other. That is avoidable void marriage. And there is no distinction regarding the intercaste marriage. Under Hindu Marriage Act, anybody of different castes can get married, and their marriage will be as valid as any caste marriage. So that is one thing. About the interfaith marriages, that interreligious marriages. See, although the Hindu Marriage Act says that this will govern the marriage between two Hindus, and who are Hindus, that is also defined. Hindus are all the people who follow Hinduism, Buddhism, Sikhism, Jainism, that is being given under the Hindu Marriage Act.
Okay.
So all these people are covered under Hindu Marriage Act. They are Hindus. Now, if suppose somebody from one partner is from another Abrahamic religion, that Islamic or Judaism or Christianity, now how their marriages will be registered or governed? If you, although there is no rule or there is no system of conversion in Hinduism, so if you can get under the Special Marriage Act, your registration of marriages will be under Special Marriage Act. In that case, otherwise, that interreligious marriages are not governed under the Hindu Marriage Act. That is what I am trying to state. There is a very famous case, if you might have heard about Lily Thomas case. So that man was converted to Islam, and he got remarried or married the second wife. So that stating the fact that I'm now a Muslim, I can marry more than one.
Yeah.
But the Lily Thomas case, it said, the Honorable Apex Court said that only for the purpose of marriage, if you're getting converted, that won't be allowed. So these are the laws for that.
Right. And Under the Hindu Marriage Act, can both the husband and wife claim maintenance? When we talk about,
Yes, under Hindu Marriage Act they can,
yeah,
but normally there is a Maintenance Act.
right.
So not Marriage Act. Marriage Act doesn't govern regarding this maintenance part.
Hmm.
There is a Hindu Maintenance Adoption Act is there. So Act is governed through the maintenance part is governed through that act.
Okay.
Now you have to understand, earlier the Republic of India had proposed a Hindu code bill.
Hmm.
A Hindu code bill was one bill, one was supposed to be one law which governed all these aspects, from marriage to maintenance to succession to adoption, everything.
Hmm.
But this was opposed at a very large scale. So the idea of Hindu code bill was dropped, and substantive acts, different small acts were implemented later on. So there was a Hindu Marriage Act, there was a Hindu Succession Act, there was a Hindu Maintenance Act. All these acts are there. Now, mostly what people do is they claim maintenance under the secular provision. You can call it a secular provision. That is the under CRPC 125, section 125 of CRPC, and under BNSS. I'm sorry, I'm not registering the section right now, but the same provision has been there in the BNSS also. So under 125, anybody, the wife can go and file a claim that I need maintenance from my husband.
Okay. So since you mentioned the new criminal code, which is the BNS or BNSS, how have they changed the way cruelty or domestic violence is handled? Um, is there any change? Is it similar?
See, I don't see much a change
Hmm.
because, like 498, IPC had a provision of section 498, which was talking about adultery. It was a criminal offense. In 2000, back in 2018, the Honorable Supreme Court decided that 498 is decriminalized adultery.
Yeah.
Although it is a civil wrong and it can be a ground for divorce,
Hmm.
but it is no more a criminal act.
Yeah.
So it has been decriminalized. So that has been removed in the new BNS. And apart from that, I don't see much a difference because, see, maintenance provision is there, and it is very similar to what it was earlier. Earlier, it was there in the CRPC. And if you will go into the understanding of the criminal system, the idea of BNS and BNSS is basically that investigation has been made more people centric.
Hmm.
It was not. It is not more prosecution based approach. Now it has been made more of the persons or the individuals' rights have been taken care of. So if there is a domestic violence cases, and if there is an allegation of domestic violence cases, you can find uh, I would say that these investigation principles which are there in the BNS. Now you have a notice under section 35, and earlier it was 41A after Ranesh Kumar versus State of Bihar judgment.
Hmm.
Now in the BNSS it is under section 35, so you have to send a notice. Then you have to start a preliminary investigation. Then after preliminary investigation, if you find there are credible evidences, then you can register an FIR about the police. So these provisions has been made, general provisions have been made,
Yeah.
and these will bring the difference. And Honorable Supreme Court has, in various cases, every day they are laying down new guidelines, extending the guidelines, expanding those guidelines, that what can be done, how this needs to be tackled into. See, recently there was a judgment where the Supreme Court has upheld the Allahabad High Court's judgment, where the Supreme Court also asked the wife to formally write an apology in a newspaper,
Yeah.
because the wife was the IPS officer, and there was only false allegations were there, and the husband's father was in jail, remained in jail for more than 3 years. So the court has asked them to formal apology, and they laid down few guidelines that how these marriage or domestic violence cases, if there are any allegations, how these needs to be handled. So as I was telling you, that there should be a preliminary investigation, PE is there, preliminary inquiry. Now, in one of the case, the Honorable Supreme Court has also held that, sorry, that in a domestic violence case, if there is, then a mediating committee, a committee has to be formed at a district level. The case will go to them. They'll call both the partners. They'll try to understand what is going on. If there is an issue, so all these things are being done on an everyday basis. So that can bring, and that will bring the changes.
Right. And is there a different way in which, these new laws recognize live-in marriages or, live-in relationships?
Pardon.
Um, I'll ask you again. So are there any new changes or any new way in which the law recognizes live-in relationships or partner rights?
Yes. So these are in the questions. Again, I'll start with the Honorable Apex Court judgment, Supreme Court judgment. In one of the judgment, the Honorable Apex Court has held that if live-in partners are staying there as a husband and wife for, say, for a considerable period of time, be it 5 years, 10 years, then you have to consider it as a marriage. So, although there was no marriage, from there you will see the principle has been followed in the Uniform Civil Code brought by the Uttarakhand government.
Yeah.
Now, Uttarakhand government has brought an UCC, and which states that if you are a live-in partner, you have to give it in writing to uh, the district authority, stating that see, we are a live-in partners, we are living together. So that safety is the concern, and other related aspects of the marriage, and the living cohabiting partners are there. So these things needs to be checked into, and everybody should ensuring the safety of both the individuals. So these things have been brought under the UCC. Now, if the central government comes up with the Uniform Civil Code, they might bring these things. We don't know what will happen. So
Right.
yeah, these are the things.
Right. And when we talk about the Hindu Marriage Act, what then is the process for separation or divorce?
So yes, separation. Now, one of the most important aspect is of separation. We have to understand the historical context. Under the Hindu marriage system, there was no um, system of separation. One thing, that is one understanding. Now, I'll give you another understanding. See, there is under Artha Shastra, there is a proper provision of family law, and where it says that if the husband so goes for a, say, more than 7 years, or if he becomes of unsound mind, or if he does any criminal and he is being punished, given the life, in those cases the wife can remarry, or can leave. So you will find instances in the ancient texts also where there are provisions has been held for the separation. Now, coming back to the Hindu Marriage Act. Now, first thing that is, there is the judicial separation, section 10. of the Hindu Marriage Act. Judicial separation is, see, if between two partners, husband and wife, if things are not going well, now they can go to the court and ask for a judicial separation. They can file a petition, say that we want to live separately. Now the idea behind that is the court will order, looking at the circumstances, the court will give an order that you both can live separately. Now the idea behind is that you go and live separately, and if you find that you can live together and there can be amicable solutions, your disputes can be sorted out, and then you can live together, or any one person can also go to the court. It is not that always a joint petition has to be filed for judicial separation. Now, after judicial separation, the main provision for divorce is section 13. Section 13(1), (2), and section 13(b). So under Hindu Marriage Act, section 13 delineates what are the grounds for divorce. So if the person has deserted the wife, if it becomes a crime, does a crime, and if there is a domestic violence, there is cruelty against each other, then they can file a divorce cases. And under 13(b), it is called mutual divorce, that both the parties can go to the court and file a joint petition, or separate petitions, but jointly, that we have mutually agreed upon that we want to be separated legally, and divorce may be granted to us. So that is there. And under 13(b), once you file a petition, you are given a cooling off period of 6 months. 180 days. And after cooling off period, you will once again be called, and you will go to the court and say, yes, we have lived for 6 months. There is, at that point of time, you have an option to either withdraw your case, saying, no, we can live together, or you can go and say that, no, we have understood, we have decided that we don't want to live together, so let's do it, just separate us legally.
Right. And is it true, or what is your opinion on the fact that the new criminal laws simplify or fast track, the justice in matrimonial cases, whether there are cases of cruelty or domestic violence?
Honestly, I don't believe that it will fast track as such, because any process, any procedure, if it needs to be fast tracked, then you will have to fast track the general provisions. There are no special provisions have been made in matrimonial cases. If I am right, if I can recollect it correctly, I don't think so that any new provision has been inserted in the BNSS where it says that if there are matrimonial disputes, it needs to be completed within few days. Like, for example, if there are rape cases, the BNSS has made the provisions of the fast track courts. Needs to be done within 60 days or 90 days. So these are things charge sheet has needs to be filed. Now, for matrimonial cases, I cannot recollect right now that if there is any special provision has been made. In my understanding, there has been no special provision of fast tracking that matrimonial disputes have been made.
Right. And then do you think in case of divorce cases, is mediation a good option rather than going for your courts? Is mediation a good option for settling the
Mediation
divorce?
is a good option. I can give you an example from my own experience. So at that point of time, I think so it's 2017. It's a matter of 2017. So there was a divorce case, and it has come to the High Court. Now, what happened? there were some remarks by the Honorable Judge, and the Honorable Judge said that you both will see what can be done. Can you amicably sort it out, or I'll go and remark harsh words against the parties, trying to reconsolidate between the parties. Now, the court entrusted my senior that you talk to these people, both the persons. My senior called them and then tried to understand what is the problem between them, what are the issues that is coming up, how can that be solved. So all these things were there. They were adamant, no, we want to be live separately, we want to file a case against each other, blah blah blah. Everything was going on. First, my senior tried to do it in a very soft way. Then my senior said that in a very aggressive stance, took aggressive stance that if you don't follow and if you don't amicably sort it out, then there will be a problem for both of you. See, the idea of any lawyer or any judge, the first idea is that you have to save the marriage. The moment a case comes to you of a divorce case or a matrimonial dispute, try to solve it so that the marriage can sustain. It should not be like, say, murder case or a rape case, that once there is a rape, you will start solving it. No, please mitigate and do all the talking and let it be slide down. No, that is not that case in matrimonial cases. It is under our ethical considerations as a lawyers that we also have to give time so that the parties can amicably sort it out their disputes and can live together. So the first thing that, as I was telling you, these things were done. Then my senior told them everything and then said, then you can go and come tomorrow. If you don't come to a conclusion together, then we'll have to go, we'll see what the court does. So next day in the morning, they came and they said, sir, we have talked whole night and we have decided that we don't want to stay out of this marriage. We don't want to be separated. So it is like that. What was your question? Sorry.
If mediation, if mediation,
yeah, mediation
is a good option.
Yeah, about mediation. So see, it was a mediation. Now I'll also give another example. I was handling a case of a mutual divorce case. So I filed a petition. What had happened in that case is that both the girl and boy, without telling their parents, got themselves as a in a registered marriage before the registrar. Now, what they thought, they were both young. What they thought that once they'll register their marriage, they'll go to their houses and they'll convince their parents that, see, we are now married and we want to live together. You have to agree to that. Somehow, they could not tell this to their parents. Now the male, that husband's family, started pressuring him that you need to get married and all that. They didn't tell their parents. And the girl's parents also started telling them. Now they came to me saying, sir, this has happened. Now we don't want our marriage to, we don't want to tell our parents, and 1 year has since our registration of marriage has passed, and since then we have not lived together, and there have been differences come up with before us. So we filed a petition. We went to the court. Then court appointed a mediator. The mediator called them both, tried to talk them that, no, why are you getting separated once you have been registered your marriage? They asked me what should I say. And say, if you will say that there are differences and we cannot sort our differences between each other, then the mediator will try to solve it out. So if you want to live separately, you have to go and say that no, we don't want our marriage to continue. We
Yeah.
want to be separated. But that mediation comes into picture, and many a times mediators help in saving a marriage. That is my understanding.
Right. Great. I think those were all our questions for today. Thank you so
Yeah.
much for this insightful discussion and helping us understand how the legal framework around marriage works, and also how the new
Thank
criminal
you.
codes are changing matrimonial cases. And I would just like to say that one takeaway from today's discussion was that know your rights, read what the law says, and don't hesitate to seek legal guidance when you need it. And thank you so
Yeah,
much
yeah,
once
sure.
again.
Thank you very much. Thank you for having me. It was an opportunity to discuss with this, and if once it will
Yeah,
go out to the people, they'll also understand what laws are there and what can
definitely.
help them and can be
Yeah,
done. So
yeah.
thank you for having me.
Thank you
Thank
so
you for
much,
giving this.
sir. I will see you again when we have another podcast for another discussion. Thank you so much. Thank you.
Thank you. Thank you.